Yes.
All right, are you prepared with your opening statement?
Yes, Your Honor. May it please the court
You,
have permission to move about the law, please?
you may.
No one can see this coming. No one can see this coming. No one could predict what happened. Hindsight is 20/20. These are not my words. In the course of this trial, the evidence will show that these are the words of the staff and teachers who will hear from in this case. These are the people who were present and were affected by the shooting that occurred, the tragic shooting that occurred at Bridge Neck Elementary School in January of 2023. These are the words of Dr. Ebony Parker's accusers. Their accusers. These are the people who were her coworkers. They were her colleagues. They were people that relied on each other to make decisions. They were people who understood that a public school setting is a community and decision-making is cooperative. Although there is hierarchy, decision-making is collaborative. Those at the top, the so-called administration, depend on reliable subordinates, but they are equals. They are equals in the sense that everyone must exercise independent judgment and discretion. They need to use their minds. The world is a complicated place. There are no easy solutions. There are no simple stories. The law recognizes this. The law recognizes that there is such a thing as hindsight bias. Fine. Hindsight. Everyone's heard the phrase, hindsight is 20/20. You've heard different variations of this. There's Monday morning quarterbacking. This is something that is embedded in the fabric of our life. It is common sense. It is also something that is a bedrock of our system of justice. The law knows that it is unfair. It is fundamentally unfair to judge another person's decisions based on stuff that came up after the fact. We all know this. We don't need a law textbook to tell us this. We know it in here, we know it in here. And guess what? That is Virginia law as well. The law requires you to examine people's decisions at the time that they make them in light of the information that they had. Why would the law do that? Because that's how people make decisions. None of us, no one sitting here, not me, not anyone in this courtroom, makes the decision with the benefit of hindsight. And that's a hard thing to get past. It's a very difficult thing to get past because when you hear about the tragedy, no one's disputing this is a tragedy. When you hear about what happened to Ms. Warner, we know this is tragic. We know this should not have happened. But you will hear from Dr. Parker's former coworkers, her associates, her former confidants. They will tell you this evening. They will tell you what they did. They told law enforcement. They told investigators. They told numerous people after the fact. No one could have predicted this. No one could have seen this coming. No one could have imagined that a 6-year-old first grade student would bring a firearm into an elementary school and shoot their own teacher. And this just isn't like speculation. This isn't something that a lawyer is making up. You will hear it from your own witnesses. You will see it with your own eyes. You will see surveillance. You will see video testimony. You will hear from experts. And you'll be able to judge for yourself whether or not this was foreseeable. That's the heart of this case. But as everything in law, it's always a little complicated. Nothing's simple. And what I mean is this. There's at least 2 or 3 unusual aspects of this case. I told you that the law recognizes that people make decisions in the moment. You can't judge them with stuff they didn't know at the time, with the benefit of hindsight. You don't judge it based on because this tragedy happened, it was terrible, it was a horrible outcome, therefore someone needs to be held accountable. That is not how the law works. And even if you decided, when you hear some of this testimony, you think to yourselves, I would have made a different decision. I would have made a different call. That's not the standard either. It is difficult, I know. But you were selected. You sat through that painful selection process all yesterday. That was for a reason. You were selected for a significant special purpose. It's because you were selected because you can be fair, you can be impartial, you can be unbiased, and you can view the facts of this case like no one's looked at it before. You talked about in voir dire, the fancy word for jury selection, all the media coverage, all that's been going on. We're in a court of law now. We're in a court of law now. And that's when you get to hear the facts. That's when you get to hear from the witnesses themselves who will have to come and sit in that stand and look at Dr. Parker and face her and confront her. And say to her face that this was foreseeable. This case is unusual. Ordinarily, under the law, in any negligence case, you got to prove certain elements. That's always true. Elements are the bits and pieces that make up a claim. They got to prove that Dr. Parker owed these people a legal duty, that they breached that duty, that they caused Ms. Werner's injuries, and they can establish the damages. That's true of any negligence case. One thing that will be hard to grapple with in this case, and I know, and I want to give you a preview now. When it comes to a legal duty, usually the question is easy. You just look up in a law textbook, you look in the code, it's written down someplace and it says, the law requires you to do this. The law requires you to do that. The law requires you to not do this, not do that. It's written in black and white. And if we had that type of case, this would be much easier. We don't have that type of case. This is a case where the plaintiff has alleged that my client has assumed a duty. Assumed a duty, meaning that under Virginia law, even if the law does not impose an obligation on you to do something, even though it is not written down somewhere in a book that says Mr. Hogan has to do this or that, sometimes you can volunteer for it. You can raise your hand and say, I'm taking on that legal duty. I'm taking on this obligation to do something that the law doesn't require. It may seem crazy, but that's what it is. That's how it works. And you're required to apply that law. But because that is such a significant undertaking, to raise your hand and volunteer to do something that the law doesn't make you do, ordinarily, you got to meet some very stringent requirements. And you'll hear about that. The court will give you instructions in the law, will give you guidance. We'll come back up here and explain it the best we can. But what it comes down to is in a case like this, where there is a 6-year-old child, something so unusual, and you'll hear the testimony will establish this is not an everyday occurrence. In fact, it is virtually unprecedented. In a case like this, where it is done by when someone suffers harm due to somebody else, pulling the trigger of a gun. That is third-party criminal harm. That is third-party intentional harm.
Your Honor, I hate to do this, but I have an objection at this point.
So your objection?
Your Honor, he is certainly going beyond the scope of what is allowed in an opening statement and getting into argument. I restrained from arguing the case, and I'd ask that he do the same, Judge.
You have a response?
I do, Judge. I think that we gave counsel wide latitude in voir dire and jury selection to instruct the jury in the law, make sure that they can abide by those instructions. That applies here as well during opening statements. I'm not arguing the law. I'm stating black letter law and making sure that they understand how they should have the framework so they can make sense of this case.
I'm going to overrule the objection.
Thank you,
Let me
Judge.
continue.
I'm not going to give you a law lecture. You're going to hear plenty of that later. But what you need to know is that in a case like this, where someone pulls the trigger and it wasn't Dr. Parker, if you raise your hand to say, I'm assuming a duty to exercise care to safeguard you or protect you, when the law wouldn't make me do that normally, you have got to have a promise. You've got to have an agreement. It's got to be express, meaning you got to say it. It's got to be unambiguous. And you heard counsel mention that she had to acknowledge it and say she claims that Dr. Parker made this promise just by being an administrator, by raising her hand and saying, I want to be a public servant. I want to come here and I want to educate the children in my community. By raising her hand, she signed up for this. You be the judges of that. You all be the judges of that. The other unusual thing about this case is that ordinarily the standard is the reasonable person standard. What that means is when you're figuring out when somebody makes a decision or not, you got to decide, okay, was this a violation of the law or not? Are they liable? The way you assess that is from a reasonable person standard. You just imagine what would an objectively reasonable person do given the information the defendant had. In this case, we got to go beyond that. For them to prevail, for them to recover, they need to establish gross negligence. That means that even if it was reasonably foreseeable, even if Dr. Parker or any other defendant in this type of situation should have known or should have known what was going to happen, that's not sufficient here. They need to show gross negligence, and what that boils down to is indifference. Indifference, not inadequacy. That is what you need to remember. Remember that as you're listening to the evidence. Indifference, not inadequacy. What that means is if you hear the evidence, we come back up here at the end, and you're thinking to yourself, I would have made different decisions. I don't agree with what happened here. It's not the same. They need to establish indifference. They have to establish that our client, Dr. Parker, exercised not even the slightest degree of care. If the evidence shows after everything shakes out, and you decide and you consider it, and you come to the conclusion and you think, look, I would have made different decisions, but you can see the evidence establishes that she exercised some degree of care, she did something, even if it turned out to be insufficient. That's the law you need to apply in this case. That's the way you need to think about this case. Carry that with you when you listen to the evidence. Carry that with you when you listen to these witnesses take the stand and tell the story of what happened. Because you are the judges of credibility. You have to decide who's telling the truth. And you heard in jury selection, counsel emphasized, he asked you to be brutally honest. Brutally honest. That's what the law requires of you. He's right about that. Ask if these witnesses are being brutally honest. Think about that. The last thing that you should know about this case, that you should consider as you're listening to all these witnesses take a stand, is that there's another duty we gotta talk about. Every person under Virginia law has a duty to exercise reasonable care for their own safety. It's common sense, just like how hindsight's common sense. The law knows that. The law accounts for it and says that should be the law. You got a duty to exercise reasonable care for your own safety. And what you're going to hear in this case is evidence that will give you pause. Counsel asks you to think about every time Dr. Parker had to make a decision. I want you to think about every time Abigail Zwerner had to make a decision. Think about that. Is she being brutally honest? It's a hard thing to do. Under Virginia law, if you're even slightly at fault and you fail to exercise reasonable care for your own safety, you generally cannot recover. There are exceptions, you will hear about them. I'm not here to lecture you on the law, but you need to know this. You need to know this to understand the story you're going to hear, because this story hasn't been told for real before. Ms. Douglas is going to get back up here at the end of this case. She's going to ask you to hold true to the promises you made during jury selection, that you will follow the law, that you will listen carefully to the evidence, you will weigh it, and you will come to a judgment. What I want you to think about. You are not judging Dr. Parker's conduct. You are judging the evidence. Apply the law. Think carefully. And ask yourselves, is it really foreseeable that a 6-year-old child would shoot their own teacher? Is that reasonably foreseeable? Was Dr. Parker indifferent? Did she fail to exercise at least some degree of care, even if it didn't work out? Did Abigail Zwerner fail to take steps for her own safety? That's what you got to think about. Those are hard questions. Think carefully. You get one shot at this case. In jury selection, counsel talked about one of your roles. Your roles is like assessing the value of a diamond. Like it's a prize. There's a cash reward at the end of this case. You gotta assess it. This is not the Antiques Roadshow. This is a court of law. You assess witness credibility, which will be decided in the crucible of court. You will look at them. You will decide. You are deciding people's lives, careers. That is what is at stake. It is not a diamond. Apply the law. Trust your instincts.